At 10,026 in the morning, I watched a defendant in a charcoal suit lean toward his attorney and whisper something that made both of them smirk. 6 minutes later, that same defendant was standing with his hands behind his back while a Deputy U.S. Marshal stepped in close enough to guide him toward the side door. And the judge didn't raise her voice. She didn't lecture. She didn't perform for anyone in the room. She just said, "I'm revoking release. Take him into custody." I've spent decades watching cases move through the federal system, and I'm going to be very careful with what I claim here. But this is true. When a federal judge revokes bail this fast, it's almost never because of a technical violation. It's because the court believes the defendant tried to reach into the process and bend it. Evidence, not speculation. Here's what this was about. The defendant, let's call him Derek, was 44, and he ran a regional construction firm that won a lot of municipal contracts. Roads, school renovations, government buildings. The kind of work that looks boring on paper and generates enormous money in real life. A grand jury indicted him on 12 counts: conspiracy under 18 U.S.C. 771, wire fraud under 18 U.S.C. 7243, honest services fraud theories, and federal program bribery under 18 U.S.C. 766. There were also 2 counts tied to obstruction theories that prosecutors flagged as likely to expand if the evidence kept coming in. The government's story was straightforward. Derek allegedly used consulting fees and charitable sponsorships as a pipeline of money to a city official who could steer bids. The official allegedly ensured Derek's company kept landing projects even when competitors underbid him. The number that mattered was $6.2 million. That was the value of the contracts the government said were affected by the scheme, not the total value of his company. The contracts tied to the alleged corrupt conduct. When Derek was first brought in, he did what most white-collar defendants do. He showed up with counsel, he promised he'd fight, and he asked the court for release. And the judge, like many judges do, granted it. Bond. Passport surrendered. No travel. No new lines of credit without permission. And the condition that becomes the center of these stories every single time: no contact, direct or indirect, with potential witnesses. Not, don't threaten them, not, don't pressure them, no contact. Period. Because the federal system understands a simple truth: witness tampering doesn't usually look like a movie. It looks like just checking in. It looks like we're still friends. It looks like we're still friends. It looks like, I hope you're doing okay. And that's why the rule is strict. Now fast forward to the hearing that morning. This was scheduled as a status and compliance conference. That phrase sounds harmless. It's supposed to be. But the night before, prosecutors filed an emergency motion to revoke release under 18 U.S.C. Section 3014-8. That statute is the mechanism. It's what the government uses when it believes a defendant violated release conditions and the court can't reasonably trust that tighter conditions will fix it. So Derek walked into court thinking this was going to be a negotiation over ankle monitors and curfews. That's what his posture said. That's what his face said. Then the prosecutor stood, looked at the judge, and said, "Your Honor, we're not asking for more conditions. We're asking for custody." And then she added the sentence that changed the temperature of the room. "We have an audio recording." Let me explain why that matters. A lot of revocation hearings are built on patterns, text messages, metadata, circumstantial proof. Judges can take those seriously, but they still leave space for a defense lawyer to argue ambiguity. Audio removes ambiguity. Audio turns a theory into a fact you can hear. The prosecutor began with the timeline. 3 days earlier, a former project manager from Derek's firm, call him Mason, received a call from an unknown number. Mason didn't pick up. He let it go to voicemail. The voicemail was calm, familiar, almost friendly. And it said, in substance, "Hey, it's Derek. I know you've been talking to people. I'm not mad. I just need you to remember what we agreed on. None of this goes on paper. Call me back. We'll get you taken care of. No screaming, no threats, just control." Then the prosecutor told the judge something else that made the defense table go rigid. The number used to place that call, she said, is registered to a prepaid account opened after the defendant's release. The device was not disclosed to pretrial services. Second phone. That phrase, second phone, has ended more bond agreements than any other, because if you're truly compliant, you don't need a hidden device. And if you have one, the court starts asking the question that matters most: what were you trying to hide? The defense attorney stood and tried to get ahead of it. He said the voicemail could be fabricated. He said voice recordings can be manipulated. He said the government was spinning an innocent attempt to resolve employment issues. Then the prosecutor did what experienced prosecutors do. She didn't argue. She played it. The courtroom speakers crackled for half a second, and then Derek's voice filled the room. And I want you to picture what happened in real time, because this is the part people miss. Derek didn't look shocked when the audio started. He didn't look confused. He looked annoyed, like someone had been inconvenienced. But then the voicemail reached the line about, "Remember what we agreed on." And Derek's expression changed in a way that was almost clinical. His eyes stopped moving, his jaw tightened, his lips pressed together into a thin line. He turned his head slightly, just slightly toward his attorney, as if silently asking, "How bad is this?" The prosecutor didn't stop there. She introduced the second piece of evidence, a bank record showing a $15,000 cashier's check purchased the day after Derek was released. The memo line was, "Consulting." The recipient, a relative of Mason's. Not Mason, not directly. A relative. That's what indirect contact looks like. Then she introduced the third piece, a screenshot of a text message sent from the prepaid number to that same relative. It read, "Tell him we're good. Tell him to keep it simple. He'll be rewarded for loyalty." Again, no threats, just intent. And then came the fourth piece, the one that made the judge stop taking notes. The prosecutor explained that agents executed a search warrant on Derek's office cloud account after noticing unusual activity. The log showed mass deletions from a shared folder labeled Bids 2023-2025, followed by a sequence of trash emptied events. That matters because deleting isn't always deleting. In modern systems, trash is recoverable until it's emptied, and emptying shows purpose. The government also had a short email Derek sent to his operations director. One line, "Scrub anything with names, today, no legal jargon, no ambiguity, just an order." By this point, the defense attorney was doing the only thing he could do. He was trying to turn intent into accident. He said the voicemail was a misunderstanding. He said Derek was calling about severance. He said the cashier's check was a loan repayment. He said the deletions were routine file management. Then the judge asked the question that ended the hearing. Not a philosophical question, not a long question, a yes or no question, a yes or no question. "Counsel," she said, "did your client place that voicemail call?" And the defense lawyer paused. In court, pauses speak. He looked down at his table. He glanced at Derek. Derek did not nod. He did not shake his head. He just stared forward, blinking slowly, like a man trying to outlast reality. The attorney finally said, "Your Honor, we have concerns about authentication." And the judge responded exactly how federal judges respond when someone tries to sidestep a direct question. "That was not my question." Silence. Then she asked again, slower, "Did your client place that call?" The attorney tried one more time. "We're still investigating, Your Honor." And that was it, because still investigating is not a denial. It's a soft landing for the truth. The prosecutor stood and delivered the final nail without emotion. "Your Honor, the defendant's fingerprints were recovered from the prepaid phone packaging located in his desk drawer during the search. The packaging included the device serial number. It matches the call records. Evidence, not speculation." At 10:32 a.m., the judge leaned back and said, "The court finds clear and convincing evidence of a violation of release conditions, including indirect witness contact and obstruction." Then she said the sentence that matters most under 18 U.S.C. 3048. The court further finds that no condition or combination of conditions will reasonably assure compliance. That's the line. That's the legal threshold. It means ankle monitors don't fix this. Home detention doesn't fix this. Third-party custodians don't fix this. Because the issue isn't where the defendant sleeps. The issue is whether the defendant respects the authority of the court. Then she looked directly at Derek. "Mr. Deckley," she said, using his last name, "you were given an opportunity to remain on release while this case proceeded. You chose to interfere. I am revoking release. You are remanded to the custody of the United States Marshals." And this is where the story becomes human. Derek's face went pale, not dramatically, not theatrically, just drained, like the blood left in a single slow wave. He whispered something to his attorney that nobody else could hear. His attorney didn't respond. He just stared down at the table like a man watching a plan collapse. A marshal stepped forward, calm, professional, not aggressive. Handcuffs came out. And the sound. This is always what people remember. wasn't loud. It was a small metallic click. But in a quiet courtroom, that click lands like a verdict. Now let me explain why this matters beyond the drama. In white-collar cases, the trial is not always the main battlefield. The main battlefield is leverage, and custody changes everything. From detention, Derek loses the ability to coordinate. Calls are monitored, communications are limited, meetings require scheduling. The comfortable illusion of control disappears. And the government just signaled something else: they're willing to bring additional charges. Because if you have a voicemail that sounds like witness tampering, and you have money moving to relatives, and you have deletion logs, you're not just risking revocation, you're inviting a superseding indictment. Potentially under 18 U.S.C. WUSC Sir 1512 for witness tampering and 18 U.S.C. CA 2519 for destruction of records, depending on what the evidence ultimately shows. Those statutes are not decorative, they carry real prison time, and they carry sentencing enhancements that judges take seriously. So here's the question I always ask when I see a case flip like this. If Derek truly believed he was innocent, if he truly believed the government couldn't prove its case, why risk everything on a secret phone and a voicemail? Think about what that implies. And now I'll ask you the question that matters for the public's understanding of how the system should work. Do you think immediate remand was the right call here once the judge heard the recording and saw the money trail? Or should judges try tighter conditions first, even when the conduct looks like obstruction? Drop your thoughts in the comments. If you want analysis based on filings, standards, and evidence, not headlines, subscribe, like, and share. And tell me, have you ever watched someone realize in real time that the system just stopped negotiating?